For all these reasons, which are set out more fully in the judgment, the Court unanimously concludes that the proposed bill does relate to reserved matters. Accordingly, in the absence of any modification of the definition of reserved matters by an order in Council under Section 30 of the Scotland Act or otherwise, the Scottish Parliament does not have the power to legislate for a referendum on Scottish independence.
While disappointed by it, I respect the ruling of the UK Supreme Court. It doesn't make law, only interprets it. A law that doesn't allow Scotland to choose our own future without Westminster consent exposes as a myth any notion of the UK as a voluntary partnership and makes case for Indy. In 2014, Scots rejected ending the more than 300-year-old union with England by 55% to 45%. But independence campaigners have argued the vote 2 years later for Britain to leave the European Union, which the majority of Scottish voters opposed, has materially changed the circumstances. Scottish First Minister Nicola Sturgeon, leader of the pro-independence Scottish National Party, announced earlier this year that she intended to hold an advisory independence vote on October the 19th, 2023, but that it had to be lawful and internationally recognised. However, the British government in London has said it would not grant permission for another plebiscite, saying it should be a once-in-a-generation event. Polls suggest voters remain evenly split over whether or not they support independence, and a vote would be too close to call. The Scottish Government's most senior law officer had asked the UK Supreme Court whether the Scottish Government could pass legislation paving the way for an advisory second referendum without the approval of the UK Parliament. The Supreme Court ruled that it could not.